Hey guys, this is Josh Nelson with Nelson Elder Care Law. I'm happy to bring you Live with a Lawyer every Wednesday at 3 p.m. where we answer any of the questions or you may have, talk about some of the concerns about going through the estate planning and elder law process so that you and your loved ones can make more informed decisions. Today, we're going to talk about what happens whenever we've nominated an agent, such as a power of attorney, advanced healthcare directive agent, or even an executor, and either that person cannot or is not willing to serve. Join us today, bring your pen and paper, and we're going to talk about some important stuff. Whenever you nominate somebody as your agent, there's different types of agents. Some are considered fiduciaries and some are considered non-fiduciary. If you have somebody like an advanced healthcare directive agent, they actually don't sign any paperwork accepting that role. That's considered a non-fiduciary agent. What that means is that whenever they get appointed in that role, they may not even know. It could be something where if your lawyer's doing the things right or you're doing this yourself, you're going to notify them. They're going to have a copy of this. Whenever you work with Nelson Elder Care Law, we actually give you PDF or digital copies that person's going to have on their phone just in case something happens to you. They don't get surprised or they don't have the problem with not having that tool whenever they need it. But often, advanced healthcare agents never know that they're nominated in that role. On the other side of things, you have the actual fiduciary of a power of attorney. And with the power of attorney in Georgia, that person accepts the responsibility by signing in front of a notary saying that they accept it. That person has very, very clear responsibilities. Whenever they sign, there's actually some powers that they don't get unless they accept them. And that person has to do what's in your best interest, even over their own. That's what a fiduciary is. And then you have kind of the in-between spot, which is an executor named in a will. This causes a lot of confusion because people think that whenever they're named in a will, they're just automatically that executor. Unfortunately, they don't become that executor until they actually take that will down to the probate court, file a petition, and take an oath saying that they're going to do what needs to be done to diligently uphold the will and the estate. I could actually name any one of you guys as my executor, and you'd never know until I died. That doesn't mean that you have to do it. You still have to accept that responsibility whenever I die. More commonly, what happens is we appoint somebody who, if our spouse predeceases us, so they cannot serve, or even if they haven't predeceased us, maybe they aren't in the position to serve because it's too stressful. And so that gets us to the point of what happens if the person cannot or will not serve. In the existence of a power of attorney, there's hopefully a successor agent there that can take that responsibility and move forward with it. The same with the advanced healthcare agent. Often in a will as well, we'll list our spouse first as the executor and then have one of our children or a sibling or close friend listed as a backup. In that case, that backup would then need a copy of the will. They take that down and they'd be appointed by taking the oath and filing the petition as your executor. Whenever we start talking about what happens if they take that oath and then they don't do what they're supposed to do, that's usually a pretty sticky subject. A lot of times that's going to end up with attorneys getting involved and sending what's called a demand letter, which says we either need you to do what you're supposed to do or we need you to pass it on to the next person. One of the problems that you run into is what happens if everybody listed is dead or incapacitated or unable to serve. So whenever you're serving as a fiduciary, especially as an executor, if you have things like a bankruptcy on your credit report, if you're a felon, you usually aren't able to be appointed into these roles because you can't get bonded. There's not a bond company or insurance company out there that will guarantee that you won't steal the money and run if you have a felony or if you have a bankruptcy, things like that. And so if either the people listed are dead, incapacitated, or unable to serve, then what happens? In the case of an advanced healthcare directive, the state has a list that goes through order that says it starts with the spouse and then the oldest kid and then the other kids and then the parents. It kind of goes through the order of people that get to make those decisions if you can't make your own. Otherwise, there's a court process called a guardianship that allows for a judge to make a hearing, hear different sides of an argument, and appoint somebody to serve in that role. For a power of attorney, there's no order that it goes through. You do have to have successor agents, or you do have to go get a court to appoint somebody. That's called a conservatorship. For a will, if there's nobody available to serve, almost anybody can petition to be the executor. It doesn't mean that they get everything, but in the state of Georgia, they do get a fee for serving, which is generally going to be 2.5% of what comes into the estate, as well as 2.5% of what goes out. The reason that we don't just call that 5% is because they do get extra over the 5% if there's interest or money that accumulates in value. So say that you had a CD that pays a little bit of interest, it ends up being a hair over 5% total to the executor because it earned money while it was in the estate. Usually, it's going to be a sibling, a friend, or a child that serves if it's not your spouse. But again, anybody really can petition for that. If you have any questions about this, or if you have some power of attorney or advanced directive tools that don't have spouses with successors on there, such as kids or siblings or friends, or if maybe your children aren't able to serve in this role, it's important that we talk about things like professional fiduciaries to make it so that you have somebody that can always step in that you know, like, and trust. If you have other questions about this, just remember we do offer a free complimentary sit down with a member of our legal team to discuss where you're at and where we might be able to help you get to. We care about making sure that you're making an educated decision here at Nelson Omicare Law, and that's what we strive for. So join us next Wednesday at 3 p.m. for Live with a Lawyer again. Otherwise, I'm Josh Nelson with